Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
So, BNS, what are the major changes from the corporate's point of view? See, if you see the act of cheating, the only thing they have done is they have retained the definition but increased the punishment. So everything remains the same, that there has to be inducement and the delivery of the property thereof as it is the way it was in the earlier regime. The only thing which has been done in the new regime is from 3 years to 5 years, the punishment has been increased. Cheating earlier was part of one of the scheduled offenses under the PMLA Act. We used to file criminal cases where we used to allege cheating instead of criminal breach of trust as a lawyer, because we used to consider, because if we say the act of cheating has been committed, so the maximum punishment is 7 years, non-cognizable, you can have to, other side has to go for the court, bail, etc. But criminal breach of trust was 2 years. But now for the first time, the punishment under the criminal breach of trust has been increased to 5 years. Criminal breach of trust has been included as one of the offenses of serious nature. And what Justice Patel was saying now, in case if there is any criminal breach of trust, and we have the knowledge of that criminal breach of trust as a corporate or as an individual in the corporate, it's a duty that we need to inform the concerned magistrate. Earlier, this provision was only related to bribery offenses and the other offenses or a heinous crime related. But for the first time now, it is mandatory in case if you have any knowledge that there is a criminal breach of trust has been committed by a public servant, banker, agent, attorney, it's a duty that you have to inform to the concerned magistrate or the police station. Then the other relevant sections which have been changed, or the new things which have been brought in place, is with regard to the forgery. So as a lawyer, what we have commonly seen in the past is, if we are doing a matter in Bombay, the client is based out of Delhi and we have rushed to Bombay for an urgent filing. For the filing purposes, we have always used the company seals and other stuff. And there is a fort area in Bombay. Likewise, there is a Bengali market here where you easily get these rubber stamps and we just do the filing. But now, even the possession of these seals are covered under the offense and you can be prosecuted for that. Whether you have used these seals or not, mere possession has been made as one of the crime under the new regime. And I guess, which is covered under the section 341. Forgery remains the same. What they have done is, instead of 4 different sections, they have combined into one. Punishment has been increased. See, there is one thing which we have prepared as title, which organized crime, which I would like to take it little in detail. So there are a couple of things for which this organized crime is an important thing now. There can be multiple FIRs, multiple charge sheets for the same offense. And in any case, if you see the CBI case and the PMLA case, for the same offense, you are being tried before the CBI and as well as the PMLA case. So the moment the charges are framed, which is the prima facie view taken by the court, and charges are framed, you are covered under the definition of organized crime. So basically, it's one offense, though the Act provides that there has to be prima facie opinion taken by the court in 2 different offenses, you will still be covered under the definition of organized crime. And the maximum punishment is up to life for an organized crime, which was never there, as Mr. Desai has pointed out. For the first time, it's going to be organized crime being levied against the corporation in case there are 2 cases. For example, you take builders. There are numerous cases by the persons who have booked their flats. There are 10 FIRs in different jurisdictions. If 10 FIRs, there are 10 charge sheets, that means they are part of the organized crime. And if they are part of the organized crime, all their promoters or the persons who are sitting as CEOs, MDs are all part of the organized crime. In addition, you will never get the funds, but the main problem would be, in case the organized crime is revealed, you will never get bail. Bail would be an uphill task because the allegations are of organized crime. And how it's going to play around with the courts, we will have to see how the courts have dealt with, or they're going to deal with the offenses related to this offense. Now, there is one section which was introduced but has not been notified, as with regard to section 106, which was rash and negligent driving. We have seen cases of BMW expose. Recently, we have seen the case of Porsche in Pune. 10, 20 years back, where Mr. Nanda was involved in a BMW case. It was for the first time when it was argued that instead of 2 years, the punishment for rash and negligent should be 10 years. But that time this section was not available. So the allegation was it was culpable homicide not amounting to murder. So what they tried to bring in this time, but this is the only section which has not been notified, because what the section says, in case you have committed this crime, you have to compulsory go and report it. And if you don't report it, then you will get 10 years into prison. So which is against our constitution, because you cannot ask an accused to go and report for an offense. So in addition to these BNS, there is one more thing which has been added into the concept, is the attachments of the property. So earlier there was no concept under any of the IPC, CRPC or the Evidence Act for the attachment of the property. For the first time in the normal criminal legislature, which was available in PMLA, now your properties can be attached. Police has been given more power. The simpliciter application from a cop before the concerned court that this particular property has been bought by the promoter or the company through the proceeds of crime or XYZ, that property will be attached. And in case if after the trial, the person is committed and punished under the offense, then that property can be sold off and the funds can be kept by the government itself. So these are the major sections which have been changed or amended from the corporate point of view under the BNS regime.